Welcome in, everyone. It is Thursday, January 20th, 2022. My name is Mark Reel, and you are watching State of the Family Courts. Tonight, our guest hails from my birth state, the state I called home until I was 24. We have Attorney Deidra Haynes from the state of Indiana. Deidra, welcome and thank you for coming on.
Thank you, Mark. Thank you.
Awesome. I mean, it's exciting. I actually, last week, we had someone I had someone in my DMs on Facebook here. They're like, hey, you're from Indiana. Why have you not had an Indiana attorney on? The answer was until recently, we hadn't found the right person. I know you and I met and connected recently, and given your desire to work for fathers and to fight for fathers, it's the perfect fit. And I'm really, really excited to have you on. So I probably have more friends and family watching tonight from back home than I typically do. So I'm excited to have you. So for our normal viewers, we're going to start doing a little bit different. We want you guys to kind of get to know the attorneys a little bit more instead of kind of just rushing right in. So I told Deidra I didn't give her any of the questions. I told her we were going to do some rapid fire just to get to know her a little bit.
Yeah.
So you got 5 seconds on each question to answer, and that is it, okay?
All righty.
All right, so first question, where were you born?
Peoria, Illinois.
Oh, from the neighbor. So when did you come to Indiana then?
In 2000, when did I come here? 2009?
2009? Okay. So you've been in the state for over a decade now.
Yeah, absolutely.
Okay, so what made you decide to be a lawyer?
I was working for an employer, and I was sexually harassed, and I actually helped fight my own case. And so my lawyer actually convinced me to go to law school.
Okay, so you had a personal situation that arose, and we'll get into a little bit because you also do some employment discrimination work, which I want to tell everybody. I was educated. My education, I did management side and plaintiff side labor and employment during law school. That is something that I think, in my opinion, is a really, really good skill set to have in a family law attorney.
Yeah, absolutely.
So we'll do this. Okay, favorite book?
The Bible.
The Bible, okay. And favorite movie?
I don't really have a favorite movie. I really like sitcoms and shows. So my favorite sitcom right now would be what's it called? The Good Wife. The Good Wife.
The Good Wife. Okay. And one last one. You got 1 week vacation. No legal issues are going to pop up for any of your clients. Yep. Where are you going on vacation?
Hawaii.
Hawaii? Have you ever been?
Yes.
Okay.
I just came back from Hawaii about a month ago.
Okay. That is somewhere I've never visited. I think probably 2023 maybe for me. 2022 is going to be a pretty busy year. So
yeah, it's a long plane ride, so get ready.
Yeah, well, we'll have to be ready for first class to do that.
Absolutely.
For that first class flight. So I'll kind of wrap things up. We'll tilt to the legal side of things. So you labor and employment, and then family law, and I think you told me about 95% of your family law clients are fathers.
They are.
So
95.
So why fathers? What led to that? Was it intentional? Was it accidental? What happened there?
Well, it was intentional. As I was growing up as a young child, I never knew my biological father. And I hated the fact that I didn't know my biological father because my other two sisters, they knew their fathers. And so it was very hurtful, very painful for me not to know my own father. And then at the age of 42, I'm 45 now, but at the age of 42, I finally realized or found out who my father was. And at that time, he still didn't want to acknowledge me as his daughter. We did get a DNA test, but I found out that it was my mother who kept him away from me. And so I had just vowed, I just made a vow to myself when I was going to law school that was one of the things that I was going to do was fight for father's rights because for the very fact that I didn't know my father. And I knew as a child, I went through a lot of suffering through rejection and abandonment issues, and I didn't want another child to have to go through what I had experienced.
That's awesome. And I mean, I think that's sitting on the opposite side of the table, I think, of a lot of individuals and our regular viewers, Ted Bush, Sean Kohlmeyer, a lot of the men where they were on the other side of it, where they may have been the
Uh-huh.
father who is withheld. You have a very different perspective of that, and a very powerful perspective
Yeah.
in terms of what happens when a father is taken out of someone's life and the trauma that you had to deal with and you had to
Yeah.
go through as an adult to kind of get everything situated.
Absolutely. Because even as an adult, I struggled with father issues, even through my marriage, because of the issue of just not trusting that a man would be there. And so it's
Mm-hmm.
so much, it's greater than just the child not having their father involved. It really does carry a stench into adulthood and how that affects a woman,
Yeah.
or a man, as they grow up without their father.
Yeah, that's definitely very, very powerful and a different perspective than the people who are usually vocal on this issue.
Yeah.
It gets the equal and shared parenting or father's rights, however you want to place it. Usually, the opposition wants to say it's the angry dads club, it's
Mm,
deadbeat dads. And
right.
when we have voices like yours out there, that can be very, very powerful. That no, this isn't a movement about dad. This isn't a movement about men. This is
Right.
something that impacts children very deeply for the rest of their lives.
Absolutely. Absolutely.
All right, got one last question, and then we're gonna
Okay.
parlay into the legal stuff. So you get one word. Describe Indiana family courts.
Oh, Mark. Um, we're getting there. I know that's two words, but getting there.
Getting there. I honestly I think, and I talked to a ton of attorneys in this space, and as much as it's awful right now, and there are terrible things that happen, I go talk to anybody who, and one of the first things a veteran attorney will tell me is, hey, what was it, David Pissarra, Michael Lambert in Alabama?
Mm-hmm.
They were like, hey, 15 years ago, it was
Yeah.
completely different. You
Yeah.
were going to get every other weekend and that dinner visit on Wednesday, and that was your
Yeah.
best hope.
Mm-hmm.
And now I sit here and I tell clients, like, all things being equal, if work schedules don't get in the way, if there's not any
Yep.
allegations, if there aren't any issues, these judges, I can get you 40, 45% at minimum.
Yeah.
So I think that's very fair on a national level
Oh,
that
absolutely.
we're getting there. And I tell everybody every week, it's a snowball that's rolling downhill.
Mm-hmm.
We're at 2 states with 50-50 presumption in parenting. We had 6 states in 2021 pass better laws.
Wow.
This is something that went from a fringe movement to
Uh-huh.
something that is rolling downhill, and we're going to see, I think, major change in the next 2 to 5 years.
Yeah, I believe that. Definitely.
So we'll transition here, and the first thing I want to say before we start talking anything legal, Deidre and I are both attorneys. I'm barred in the state of California. She's barred in the state of Indiana. Nothing we say on here should be construed as legal advice. It is for educational purposes only. We'll drop the contact information for both her and I in the comments, but nothing should be construed as creating any sort of relationship or anything we say being legal advice. There's nothing at all that can replace talking with a local family law attorney who knows the
Absolutely.
rules in your jurisdiction. So wanted to get that disclaimer out of the way before we
Mm-hmm.
hop in. So the state of Indiana, much like the state of California, we always start out with the NPO scorecard. The state of Indiana grades out as a D minus. There are only 2 states, Delaware and New York, that grade out worse than where Indiana and California sit statutorily. So when a dad comes into your office and
Mm-hmm.
asks, "What's this process going to look like? What can I expect?" What do you tell them?
Well, although the you talked about the grade being D minus, where I have been primarily practicing, which is Indianapolis, Indiana, that area, the Hamilton County, which is Noblesville, Fishers, Carmel area, with it's been really good. I would really say that we're on the A plus scale, and that's
Mm-hmm.
why when a father comes into my office, I tell them, listen, we are on a even playing field. Um, there has been such a stereotype that the courts have favored mothers, but the stereotype has been developed in my opinion, by mothers, um, because fathers don't know their rights. And so when a stereotype or a rumor gets out there and has been out there for so long, it tends to come across as the truth. And if you don't refute it, um, it lives on. And so
Mm-hmm.
I have told many of my clients, listen, we are coming with a fair playing ground. The only way when we're not coming on an even playing ground is when you haven't really been in your child's life. And then we have to kind of reunify and reintroduce you into the child's life. But if you have been that father, has been a constant player in your child's life, we're going to shoot for joint physical custody.
Mm-hmm. Yeah, I think that's something. I think you touched on a really, really good point. And this is something that a lot of times I have to explain to my clients is there is this deep seated belief. And I think it's different in each generation
Uh-huh.
and it's different from race to race
Yes,
in
absolutely.
terms of how deeply seated or what the actual beliefs are. There's a difference in, I would say, Hispanic families, Black
Hmm.
families, white families
Uh-huh.
on what exactly they believe a mother's role and a father's role are when there's a divorce or there's a breakup and there's a child involved. Do
Absolutely.
you see that in Indiana? I know in California, I'll be it's with say the African American community, it can be very, very perverse. It's like, dad, get away, we don't need you. And you have to
Yeah.
explain to them like, hey, that's not the case. That's something that's just generational.
Yeah.
Hispanic families can be a lot the same where in my experience, when a white individual comes into my office, a white man comes in, he's like,
Uh-huh.
hey, I want what I deserve. I want it to be fair. I want as much time with my kids.
Uh-huh.
Where the men of color are a lot more likely to say, like, well, whatever you can get me, like, I know I'm not supposed to be here. I'm like, no, you have every right. You're
Yeah.
every bit as important. So what's your experience in Indiana on that?
It's exactly what you just said. And many times, I'm also a licensed minister as well. So many times I have to play both both roles, the attorney, but
Mm-hmm.
also the minister from a spiritual perspective, because most of my clients and my African American clients, they come into my office so beaten down, thinking that they don't have any rights. And exactly what you said, Mark, just get me anything. Just if I could just see my child just like once a week, they're happy. And I'm like, no, you deserve more than that. And so they have been so beaten down by mothers, at least the clients that I have that has retained me, that I have to convince them that you have a right. And that you have a right to fight for your child, and you have a right to be there. And just getting one day a week is not what the law is even allowing you to do. So yeah,
Yeah.
I would say that that is a generational. I say a generational curse in the African American community, where the mothers have just kind of pushed the fathers away. Like, I don't need you. Um, and it's so ridiculous. And in fact, that's what actually happened in my own experience, where my biological father was pushed away, as indicating that I can raise my own child. I grew up with my mother's favorite words: "I'm your mama and your daddy."
Mm-hmm.
No, you're not, mom. You're my mom. And because of that, it broke my heart, because I wanted to have a father. And many times my clients are coming in with that same idea. Listen, she's the mama and the daddy. I just want some time with my child.
Yeah, and you saying that, I'm envisioning. I mean, just last week had he's early 20s African American male. Mom's been withholding the kid. He's been working for a year and a half. He's
Hmm.
afraid to go into the court system.
Wow.
Finally comes into my office, and I'm like, well, what do you want? In a dream world, what do you get? And
Hmm.
his response was like, if I could just see my son for a few hours a week.
Yep.
And you have to sit there and you have to educate them, but sometimes it's not even just mom's family. That it may be the
Hmm.
maternal grandmother,
Yep.
auntie, cousins, friends, but they may be hearing that from their own family.
Hmm.
And that's where I think it's really perverse. Is there's sometimes you have the dad's family's like, yeah, you're really not supposed to be involved, just move on.
Yeah.
And I mean, I can imagine, and that's what harms a lot of guys in terms of getting a lot of custody. Is this kid came? I won't call him a kid. He's a grown man. He's in his
Yeah.
20s, but he came to me, and it's been a year and a half. So
Hmm.
now, as you mentioned, we have to go through the reunification process. You haven't been
Yeah.
involved for more than half of your child's life. Where
Yeah.
if you come in right when it happens, like we're in court in a couple months,
Mm-hmm.
and this court process may be completely over already.
Right. Absolutely.
So I want to kind of dig down a little bit more on the kind of the process and procedure. So in your area, and we'll
Mm-hmm.
just say the areas you're in, those are outside of the college towns,
Yeah.
are the most liberal areas in the state of Indiana,
Mm-hmm.
Hamilton County and Indianapolis, obviously. Um, so dad comes to you and says, let's say common story. Dad, unmarried father, comes in and says, mom's not letting me see the kid, or mom's being a gatekeeper.
Uh-huh.
You file a petition. I'm assuming for you probably have a technical term for it: custody and visitation, parentage,
Mm-hmm.
whatever it may be. What's the timeline, and what happens when you actually get into court for that first time?
Well, typically when a client comes into my office, they haven't even established paternity.
Mm-hmm.
Because in the state of Indiana, just putting your name on the birth certificate is not good enough. You have to sign the paternity of affidavit. So I usually have to, because usually when the child is born, they may have been there, but they don't know whether they signed the birth certificate or was this another document that was called the paternity affidavit. So we always have to first tell my clients, let's start there at the health department, because that's where our paternity of affidavits are located. And if we can't find it there, and if it's not there because they didn't sign it, then we first have to file a petition to establish paternity, along with establishing parenting time in custody and child support. And so that's generally our first process, is make sure they have established paternity, because many times these fathers have raised or helped raise children, but legally they have no rights because paternity has not been established. So that is
Okay,
pretty much our very first start.
that's similar to the state of Florida. That's different in California, though. To get on the birth certificate, you have to sign what we call the voluntary declaration of paternity.
Mm,
If you sign that, you have exactly the same rights as mom does. But sounds like Indiana is like the state of Florida. I believe
uh-huh.
Georgia's the same way, where you actually have to go to court essentially
Mhm.
to establish any sort of right to the child.
That's true. That is true.
Okay, and so you got to do the record search. You got to make sure the appropriate documents are filed. Or have been signed? What happens if that document has not been properly signed? Is that something you can go to mom and say, "Hey, we need to get this signed"? Is that something dad can do on his own, or do you have to get in front of a judge?
Well, yeah, you have to get in front of the judge to establish paternity, and DNA is not necessarily required. If mother agrees on the record that he is the father, then paternity can be established through testimony.
Mm-hmm.
However, if mother denies, then we do have to do the DNA testing. And then from that process, it could probably take anywhere from 2 to 3 months to kind of get this case in the courts and kind of resolved with like a preliminary order saying, listen, let's give him some custody rights, let's give him some parenting time, and then our final hearing may take up to like 4 or 5 months to get that resolved. Now, there's an issue. There could be possibly other issues, is if paternity has been established and there's an emergency situation. We're going to get into that court within the next 10 days or so.
Yeah, that's one you got to be careful of. I'm sure, like in the state of California,
Uh-huh.
if you cry wolf, the judge doesn't take too kindly to it.
Yeah, absolutely.
So
And with emergency custody here, it has to involve something like violence, abuse, neglect. I have been, I'm guilty. I have been notorious because I have such a passion for fathers, filing emergency petitions when a father is coming in my office, he's crying. And you, believe it or not, these men cry more than you would expect because they're really
yeah,
hurt. They want to see their children. So I have been guilty of possibly filing emergency petitions when there has not been a neglect or abuse, but there has been just a withholding of the child. But I've been getting better with controlling my emotions.
I will say though, I mean, I'll just be honest with the viewers. I mean, the state of California is similar. The big one in the state of California that there's explicit language. If there's threat, the child's going to be removed from the state.
Mm,
So anytime there's connection to another state, anytime there's connection to another country,
yeah.
usually gives you grounds to get in. Depends on the court. Sometimes some courthouses are notorious for just granting every single emergency hearing, and then if you get in front of them and don't have an emergency hearing, they tell you to go home. Others, I've seen nasty situations where they say you can wait the 2 or 3 months
Yep.
to get in front. So you mentioned getting in front of the judge and getting a preliminary order. What does that typically look like for dads in the state of Indiana?
Well, the preliminary order typically just simply looks like the Indiana Parenting Time Guidelines, which would mean that he would get every other weekend, his Friday, Saturday, Sunday, but return the child back to mom on Sunday. May get a midweek visit, and that is every week. And that's kind of preliminary until we get to the final hearing, so that we can kind of hash it out and say why he should be getting joint physical and why he should be participating in joint legal, which means that he has a say-so in the child's education, medical, and religious decisions.
So essentially, if a child's being withheld, that initial hearing, there's kind of a rubber stamp in the state of Indiana in terms of you're going to get 3 days or 6 days a month and maybe 4 or 5 dinner visits.
Right.
Does that impact? Do you see that having an impact long term if the dad, typically a judge is just going to say, here's the guideline? Do you see that impacting the case moving forward? Because you mentioned there usually can be 3, 4, 5, 6 month gap between that initial hearing and having a trial.
Yeah, I do. I think, I'm a father's rights advocate and, strong advocate for fathers. So I don't necessarily like it, but but when a father hasn't seen their child in so long, me being able to get the preliminary order in place is a win for us, because he may have not seen his child for 5 months or even a year. So being able to come to the table and say, listen, I'm picking up my child every other weekend is a win. And so I always tell my clients, listen, we're playing chess and not checkers. So we have to, it's a snowball. We have to kind of build up to that. And then I always tell them, listen, be consistent. Be consistent with your Indiana Parenting Time Guidelines, which is that every other week, because we can always go back if circumstances does change, and it has to be a substantial circumstance or change, then we can go back within those 12 months and try to seek joint physical custody.
Yeah, that's something, and I mentioned prior to us going on, being from the state of Indiana, doing what I do, have a lot of former friends, teammates that reach out, and one of the struggles this may be a courthouse by courthouse, but it's a common story I've heard in talking to a lot of dads who I know in the state of Indiana, is that because this standard parenting thing gets put in place, there's just 2 or 3 of them I've spoken to that have issues with mom keeps running back to court. Essentially, judge makes a decision, and the next week they file again saying we need to cut off dad or we need to slow things down. Or is it tough to get back in on a modification of that preliminary?
No, not at all. Because once we have the preliminary hearing, the judge is going to automatically set a final hearing. So it's not hard at all to get back in, because usually that is the next court date.
Okay, so you're looking at in the state. I guess it's probably different county by county. Those who aren't familiar with Indiana, there's a huge difference between Marion County and Hamilton County in the Indianapolis area. And if you are in rural Indiana or where I'm from, Howard County, where there's only a couple judges, they hear all the different sorts of cases, and you may only be 6 weeks from getting a hearing. So you mentioned, I think, a really, really good point, and I had this actually out here impact one of my cases lately. What do you tell dads? So obviously getting stamped with the every other weekend, where you're getting what most dads would probably say isn't enough time with their kids.
Right.
What are some tips for dads? You get this preliminary order. How can you improve the odds of getting more time as you head towards that trial?
Consistency. It's all about consistency. If you're asking for, if you believe that you're going to want to shoot for joint physical custody, this is the time to hit the ground running. You cannot be inconsistent with your every other week parenting time. And I'm not for sure how California labels the visits with the child, but we call it parenting time here. It used to be called
Mm-hmm.
visitation, but we determined here in the state of Indiana, we don't. The parents do not visit their child; they parent their child. And
I
so
want
I
us to go to
always,
that. We go two ways. So we have the same legal physical custody,
uh-huh,
but depending on the judge,
uh-huh,
if you have less than 50% physical parenting time or visitation, then
uh-huh.
they may go sole physical custody and then call the non-primary parents time visitation. But
Wow.
I'm with it. Indiana is one of probably 5 or 6 states that has done away with visitation and made it,
Yeah.
like Colorado calls it, parenting responsibility.
Okay.
I think that's much more fitting. You don't visit
Yeah.
your kids,
Yeah.
you parent them.
Absolutely. Absolutely. So I just tell them consistency is the key. Now, it doesn't always mean that once we go to the final hearing that you're going to automatically get joint physical custody. But I believe that showing the consistency allows him to have a better argument to try to get joint physical custody. Another thing that I always tell my fathers is try to get along with the mother. Now, why is that this is important? Because this is a strategy as well. Being able to get along with the mother, if you are actually getting along with the mother, she's going to allow you to start exercising more time outside of the court order. And then why is that key? Because next time we go modify, you can say, listen, we have been deviating from the court order. I have been keeping my child on Wednesdays, Thursdays, Fridays, Saturdays, and Sunday. And so now, because they have deviated from that, not saying that we're trying to set the mother up for failure or anything, but if
Mm-hmm.
you are able to get along with the mother, I'm telling you, these mothers will allow you to start exercising more time with the child. And then essentially, what that helps the fathers do is to get joint physical custody, which ultimately also lowers their child support as well because they're spending more overnights with the child.
Yeah, definitely. And we'll get to Indiana child support here. I want to kind of piggyback on one point you made there. And this is the probably the single biggest mistake I see dads make from temporary orders to us getting to a trial or getting to some sort of final order is exercising every bit of your parenting time.
Yes.
Some guys, I mean, I have clients who work in the logistics industry that they have impossible schedules in December. And we
Mm-hmm.
just so happen in January or February to have hearings. And all mom's attorney has to do is, hey, the whole month of December, they weren't taking one of their overnights. And the
Mm-hmm.
judge is going to look at you and say, you want more time, but you weren't exercising all your time. Or I have dads who get very frustrated when a judge grants 1 or 2 dinner visits and it's
Mm-hmm.
only 2 or 3 hours. You
Yep.
need to exercise that time if you want more, because all the judge is going to do, no matter where you're at in this
Mm-hmm.
country, the judge is going to look at you and say, if you aren't exercising all the time I gave you now, why should I give you
Absolutely.
more time?
Absolutely.
So that's a big thing. And you made a comment that made the comment section blow up on YouTube and Facebook. Working together with your co-parent.
Yes.
I'm a big proponent of, for fathers, I believe the quicker we can bring the proceedings to an end, the better off. I think
Yes.
outcomes become more in favor of mom the longer these things go along, probably because there's some bias in the court. Dads are held to a different standard on the way they communicate.
Mm-hmm.
Dads are presumed to be the aggressor no matter what.
Yeah.
So the quicker these things get away. But if you're able to get along, whether it be divorce or whether it just be child custody,
Yeah.
number one, it's going to be cheaper. Number two, it's going to be a whole lot
That's true.
less stressful. And number three, something we talked about earlier, is that it's going to be easier on your kids.
Yeah.
If you guys can
Absolutely.
joke and laugh and you don't have to go, I mean, I have parents who their kids are teenagers and they do exchanges at the police station.
Mm,
How is that beneficial to the kid? Like, your
yeah.
teenage kid probably already doesn't want to shuffle back and forth. They don't like the situation.
Mm-hmm.
But then you make them go out to a Walmart parking lot or a
Mm-hmm.
police station and
Right.
put all their belongings in a backpack and jump from one car to the other. That's
Right.
humiliating to them.
Yeah.
So,
Yeah.
one of the things that came up, and I'll pivot and ask you this question.
Okay.
So, you talk about a strategy is try your best to get along with mom.
Yeah.
What if mom doesn't want to play ball?
Well, and that's often the story. And so what I usually what I usually ask for in my petitions or my motions is what is called the Our Family Wizard app. and it's like a text messaging application in which the parents will only communicate through that application, because that can be monitored. You can't delete the messages. And so if we can show the court that father is the one that's more reasonable and mother is doing all of the cussing and the fussing and not trying to co-parent, that's going to be more favorable to my client as the father, because the judge is going to be able to see, well, listen, he's trying to co-parent with you. You're the difficult one. And so I almost always ask for the Our Family Wizard app if there's contention. If not, then, and they're getting a loan, that I don't ask for it. But it's a very inexpensive app. It's like $99 annually. So it's not that much money. So it's worth the investment, especially if you feel like the other party is contentious or going to, talk crazy to you. And we want to be able to show the court that you're the reasonable parent.
Yeah, and that's we primarily use talking parents out here, but it's the same concept where you can't delete it, you can't do. There's even some more pricey ones that will actually tell you if your tone is appropriate.
Yeah, absolutely.
So depending on the situation, but yeah, I always tell clients, no matter what, even if there's not a lot of contention, even if there's just some bickering, that hey, we're gonna do this. But hopefully 6 months from now, you two look at each other and say, this is dumb, and you can call and text each other. Yeah. But until we get something on paper, you're the one at the biggest risk. So we're going to put it all on this app so she can't make accusations.
Absolutely. Absolutely. Certainly agree.
Yeah. And then because one of I'll share everyone one of the biggest tips, or the number one thing I tell all of my clients, is that they read you your Miranda rights when you get arrested. They don't when you go to family court, but everything can and will be used against you.
Everything.
I've seen a situation where they were talking about, it had been like 2016, 2017, but they were talking about, it was when the military was dealing with like what to do with transgender individuals. How do we treat them? How do we accommodate them? And he sent her an article about the issue. And then immediately afterwards, she asked if he had gotten his doctor's appointment set up. And so 3 years later in court, they try to utilize that to say, hey, he sent her an article about mental illness. And look, she was checking to see if he had gotten his doctor's appointment scheduled. And they just screenshotted those two messages. I mean, we put her on the stand and we read off the entire transcript. But it's one of those things where you have to be careful. So for me, it's brief. Extremely peaceable. I always tell guys, hey, you should talk to them as nice as you did before you started dating. That's how nice you should be to them, and it should be directly about the child. Because if you stick to those three things, there's no way they can make accusations. So, in that same vein, what would be your biggest tips or your advice to dads for those moms who don't necessarily want to co-parent, don't necessarily want to communicate? Because that can be extremely frustrating for dads.
You got to keep trying. You can't give up, because if you give up, that's going to be your downfall. So again, it goes back to the consistency. Even if she doesn't want to communicate, even if she doesn't want to get along with you, the more that you, and I know it can be tedious or burdensome to text her every day or every other day, hey, can I see my child? Can I see my child? But the more you're doing that, and that we can show those screenshots or those text messages that this father has diligently asked mother to see the child, and she has been resisting, it works in your favor. So although it could be just a simple text, can I see my child today? Sometimes they don't even respond back. Sometimes we find out that mother has him on the block list, which is even, that much more, ridiculous. But I tell my clients, be consistent. If you really want to fight for your child, because I promise you, your child is at home, like I was, that minor child, wondering, do my dad love me enough to fight for me? Will he give up if mom keeps resisting? And I can tell you, that child is waiting for dad to continue the fight.
Yeah, that's a big thing too, because I have dads who come to me that they start out, and I always say, if she's not responding, you shouldn't send more than one short text message. I don't need you to send a novel. I don't need you to send anything that she's going to argue as harassment. It's going to be a very direct question.
Yeah.
Yeah, I want it to be a very direct question once a day. And so if it's once a day, hey, can we set something up for me to see our child or me to come pick her or him up?
Mm-hmm.
And what guys do a lot of times is that you go a week, you go 10 days with no response, and then it becomes a once a week thing.
Mm-hmm.
And then it becomes an every other week thing.
Yep.
And then it becomes like, let's just say one of your visitation is Zoom visits and she's
Mm-hmm.
messing with it and not getting on the Zoom visits. You stop showing up. All it takes is they're going to run in there and say, hey, so twice in the month of January he reached out. That's it.
Yep.
We logged on to the Zoom visit on this date and he
Yeah.
wasn't on there.
Mm-hmm.
So you have to keep trying and you have to be tactful about it because it can be a very emotional thing.
Absolutely.
But if you're very matter of fact and you're very polite and you ask once a day, they can run in there. He's harassing her. He's harassing her. I have no problem reading that transcript off to the court. And where's the harassment, Your Honor?
Absolutely.
This is just her being non-communicative.
Yeah, absolutely.
So we'll turn now because you mentioned something that I know is a little bit different in the state of Indiana than most states, and a topic that's very popular with our viewers: child support.
Mm-hmm.
So, how is child support calculated in the state of Indiana?
It's calculated using both parents' income, the gross income, and then it's also calculated in regards to how many overnights that father is exercising with his or her child, his child. And so we're taking the income from mom, we're taking the income from dad, we're taking into consideration who is paying the health care for the child, because whoever paying health care for the child will get a credit as well. And so it's basically based off of the income. It's based off if you have other children that you're paying for. That's through the court system. Now, on the Indiana Parenting worksheet, it also takes into consideration what we call legal duty, where the parent may not, or the father may not actually be paying child support through a court system, but he or she may have paying child support just out of his pocket and giving it to another mother. But I always tell my clients, listen, they're going to fight that, because that's something that also lowers your child support. If you're paying child support to someone else, but it's not court ordered, but you're paying it. So I always tell them, listen, keep receipts. Keep receipts. If you do a cash app, we want to bring that in. We want to bring that in to show that this is not just him making up that he's paying $40 a week to mother, B, so that he can get his child support lowered.
Yeah, the biggest facepalm moments for me are when those clients come in and they have alleged arrearages, different things, and I'm like, okay, well, you have receipts. We can pull credit card statements. We can pull bank account statements. And they're like, well, actually, I was giving her cash. And I'm like, okay, so that's going to need to stop. Yep. You got to be able to prove it. But you made another kind of point, and I always encourage this in the state of California and our beautifully well-run government out here.
Yeah.
The state of California, DCSS, the Department of Child Support Services, 13% of child support paid through the system, the state actually keeps. So if you're able to work with her, if you're able to put something in order, I don't know if you're able to do this in Indiana, but a lot of times in the beginning, we try to set up situations where it's like, okay, you're going to pay her $821 on the 1st and $821 on the 15th, and she's going to give you her bank account, and you're just going to wire the money over. And that takes the state out. That takes, as long as you keep up with it, that takes out the risk of a garnishment happening out of nowhere. So can you do that in the state of Indiana? I'm sure the state of Indiana is probably lower. I know most states and most red states are like 2 or 3% is what the state ends up taking, and that's usually just interest and penalty type stuff. But what would you advise dads in terms of, hey, you get hit with this child support number that, let's just be honest, that it may not be practically affordable given your situation. What do you do to kind of help mitigate that?
Well, going back to, can they actually pay the child support without going through the clerk's office? And they can. If mom and dad agree that dad can pay her or wire her the money directly to her bank account, if both parties agree to that, then it can be done. But if mother is adamantly disagreeing and she wants it to go through the clerk's office, then the state of Indiana will require it to be an income withholding, a garnishment. And so this is one goes back to why I'm telling fathers, try to get along with mom, because if you're consistent and you're not, if you're consistent with paying the child support, and you ask her, listen, can I pay it this way? And then you are consistent with paying her just through out of your pocket to her bank account. That actually helps your credit too, because in the state of Indiana, if you have a garnishment on there for child support, I mean, it's not like, you're getting garnished because you didn't pay, your furniture bill, or, a company's coming after you. It's still part of your credit report. And it still shows. And so if you can avoid that situation, that would be very helpful. But I haven't had a lot of mothers who have agreed to that in any of my circumstances. Maybe one or two I can count on my hand out of thousands.
Gotcha. Yeah. So a lot of it comes back, and we got guys still, we're still blowing up the chat with what if she doesn't work? It takes two to play ball. Ultimately, on a lot of these issues, unfortunately, there are individuals who I chalk it up as fear. I'll let you kind of comment on it. My personal opinion is when you get a mom who just is disagreeable and doesn't wants to just go to court for everything, I think there's a level of fear. And they're afraid, if I sign on the dotted line, are they trying to get one over on me? Are they trying to do this? What's your experience with that? Do you kind of notice that or get that feeling?
Yeah, it is a lot of fear, but it goes back to all of the false rumors that have been out there, and so it's so embedded in them. When a non-truth has been so embedded in somebody's spirit or in their mind, even if you're telling them as a licensed attorney, this is not true, it's almost like you have to beat it out of them to get the truth in them. You have to deprogram them to program them with the right information. So it is a lot of fear, Mark. I absolutely agree with you on that.
The worst ones are when dad, and I have a dad, and then mom is unrepresented. They think anything I say, they think anything I do is in bad faith. And you can go to them and say, hey, I'm showing you all the cards here. We want to work together with you. And they're just sometimes, especially when they're unrepresented, where you present something that's more than fair, that's better for them than what the judge is going to grant. And they're scared to sign on the dotted line on that for fear of they're going to miss out or they're going to screw something up.
Yeah, absolutely. I absolutely agree.
All right, awesome. So we're about closing in on the 45-minute mark. If you have questions for Deidra or myself, drop them in the comments. I'm going to start looking through here, and we'll take 4 or 5 questions. All right, so let me dig through here. Okay, so Deidra, they think you should run for office.
Okay, I've been told that before.
Yeah. No. So we'll go here. Bob, I believe is in the state of Indiana, and I'll just give this one directly to you here. So, do both parties have to agree to use the Our Family Wizard, Talking Parents, whatever it means, whatever your attorney recommends, whatever you want to use? What if mom doesn't agree to use it? So, do you want to kind of walk through the process of, as attorneys, what we do around a situation like that where there isn't a mutual agreement on that?
Well, yeah. So if there's not a mutual agreement and it's not in the court order, then mom does not have to agree to use the Wizard app. And this is why I always put that recommendation in any of my motions or my petitions. And usually 9 times out of 10, the judge is going to agree that the Wizard app should be used, especially in the state of Indiana. So mom doesn't necessarily have to agree. If it's in the court order, it's going to be, or even if it's suggested by one of the attorneys, it's almost 100% of the time it's going to be implemented by the judge.
Yeah, I've never seen a judge where there's a disagreement on whether one of these apps should be used, not granted. Now, most of the time, if both sides are represented, the attorneys look at their client and say, we aren't fighting this because you aren't going to win this.
Right, exactly.
Yeah. Okay, we'll take, here we go. So this is going to be in regards to communication. This is from D on YouTube. So my son's mother doesn't respond to text, calls, or emails from me. She refuses all communication. She prevents my court-ordered visitation. What can I do?
And can't
so in the state of Indiana, what do you do in a situation like this?
Okay, well, one of the things he says at the end is that he can't afford an attorney. In the state of
Mm-hmm.
Indiana, you don't necessarily have to have an attorney to go to court. We have what we call like templates, where you can actually go to the clerk's office. Well, you can't go now because the court's kind of closed because of COVID. But these templates are online where you can fill them out and you can file them with the court. And so even if mom is not or preventing you from visiting or parenting with your child and not responding to text messages, you can put that particular issue within your petition, and that will be addressed by the court. Now, I recently had a situation very similar to this where mother would not obey any of the court orders, and the judge told her, listen, if we have to come back to court about this one more time, I'm going to change custody. He's going to have sole physical custody, and you can have the parenting time. That kind of got her on the right track, and she unblocked him and started responding to his text messages. In that, he did get joint physical custody as well.
I think the biggest point is if you're struggling with it, number one is we're in 2022 now. All of the resources are available and out there. COVID may make it more challenging if
Yep.
you don't want to use technology. You can't. Their help center might not be open, that type of thing. But the biggest thing, what Deidra just said, is you have to do something.
Yeah.
If you're not represented by an attorney, at minimum, you need to figure out how to get in front of the judge and say, hey, this is what's going on. Because nothing's going to change unless you get in front of a judge. And from my experience, 80 to 90% of parties are unrepresented in the state of California in family court. If you're not represented, the judge is going to give you a little leeway if maybe something's not perfect, but you show up in front of them and you say, I'm not getting my parenting time you gave to him. And the minute the judge says that on the record, you ask how I can get the transcript from the court reporter, and you make sure you get a copy of it. And if it continues, then you file again immediately and say, hey, Your Honor, this is what you said last time, or this is what your colleague said last time. I'm asking for this change to occur.
Yeah, absolutely. And sometimes we fail to realize that judges are human. And so when they put an order in and they personally sign their name on that order that you must do this, and the mother comes back and she's not obeying what that particular judge has ordered her to do, I mean, she's human. Yeah. That judge is human. And he or she is going to feel like, are you disrespecting not only the court, but you're disrespecting me as the judicial officer who put this order in, and you cannot just willy-nilly change orders because you feel like you have the power and the right to do so. You're not in the position to do so. I am.
Yeah, and I talk about this regularly. The caseload that judges have. In some Indiana counties, these judges are handling a wide variety of cases. Out here in most counties, we'll say in Orange County, one of the cases, I think they're north of, there's 19 or 21, I believe is the number of judges who just handle family court decisions. They each see 70 to 100 cases a week. So you get that transcript and you put in there like, hey, Your Honor, so last time you said this is what was going to happen. Attached is the transcript from the hearing. I would like this to occur now because things have not changed.
Absolutely.
Because if you don't do that, there's a good chance, I think judges usually lean on the side of not making major changes. So you got to remind them of what happened. And I think this is where a lot of pro se dads go wrong is rather than saying little nudge, hey, Your Honor, here's exactly what you said 3 months ago. You just go in without a transcript, without anything, and you demand the change to occur.
Yeah.
Judges don't want to look like liars. They're, like you said, they're human. They're not. They're sitting up on the bench above everyone. Setting the rules. I know some are extremely formal and require you to do all these silly things.
Yeah.
But they're human at the end of the day.
Yeah, absolutely.
They're the people, and it's the people we went to law school with. It's the people that we go to these bar events and they're there socializing, having a beer with us.
Absolutely.
So as a pro se litigant, you have to remember that they're human.
Yeah.
All right, so we'll pull this one. This is from a Facebook user. So my kid's mom filed 2 false DCS. I'm assuming that's probably Department of Child Services. So we'll just say CPS, or out here it's Child and Family Services, cases against me. Both were closed out as unsubstantiated, and the court still temporarily suspended my visitation. So when you have a client who typically judges are going to err on the side of caution. And if
Mm-hmm.
there's an allegation with any teeth to it in regards to the safety of the children, they're not going to be afraid to, in an ex parte manner, strip visitation. In the state of Indiana, how do you go about getting that father back that visitation?
Um, I from my experience, if a DCS case has been unsubstantiated, the court is going to err on another court's ruling to decide that it must have not been enough to show that this father has done something that is neglectful or abusive. And so the areas in which I practice, or the counties in which I practice, I have not seen that happen a lot. So that's really different for me to read this particular Facebook user's comment that his parenting time was stripped away from him. But I can say that there may be situations where even if DCS unsubstantiated it, but there are allegations that the children and the dad are just, battling each other, that there needs to be some type of counseling between the children. I can see where a judge, which has happened in some of my cases, where the judge says, listen, I'm not going to strip you from your parenting time, but I'm going to order that you and the child get counseling together. And as you guys get counseling together, I'm going to allow you guys to build back more parenting time and overnights. But just to strip the parenting time, I haven't seen that happen.
Unfortunately, here in California, if there's any teeth at all, and it's very lopsided. I see it a lot more where we provide allegations against mom that have teeth and they don't do anything, but make allegations about dad or his family or his living situation, and they'll strip it away. And there are instances where you don't get another court date, where it's just kind of floating out there. So in those situations where you end up doing nothing is the worst thing you can do.
Yeah,
if
absolutely.
This is the case, if you have two false report or two cases that were deemed unsubstantiated, so they did not find any evidence to support, most of these organizations, they're called different things in different states. I think colloquially we refer to them as CPS. Unsubstantiated means they didn't find evidence.
Right.
And they don't say it didn't happen. They just say there's no evidence that it occurred. You need to get back in front of a judge and say, hey, this was the reason you got rid of my parenting time. It was unsubstantiated. I need it back.
Yeah, absolutely.
So dads run into this issue, and I think it's a societal thing. I think dads are always, whether it be 2 months or 2 years behind on just acting. I think it was most obvious coming out of COVID, dads paying child support that had lost their jobs. In California, you can't go backwards. You can only modify from the date of filing forward. So these dads come to me and they're 18 months out of work, and they haven't been able to pay child support. They're like, hey, what can we do about the last 18 months? Well, unfortunately, statutorily, nothing, but we can modify it moving forward.
Yeah, and that's the thing here.
Do something.
Do something.
Do something. At minimum, like I said, the judges a lot of times are going to give you a little leeway, maybe if you didn't put all the right words that an attorney would put in them. But get in front of a judge. That's the only thing that essentially you're guaranteed is there's some way that you can get in front of a judge and say, hey, this is what's going on.
Yeah, and definitely, it really goes back to when you say do something, it's going back to using your resources, getting on the internet. There are templates, at least for the state of Indiana, out there that will walk you through. I mean, it's already filled out. You just have to kind of put your name in and then put a little blurb of what you want to bring into the issue into court. And please don't forget the proposed order, because I have seen where individuals will fill out their motion to modify, but they didn't attach or complete the proposed order, so the judge can make a ruling to set a hearing date, and the judge will do nothing with your motion because you didn't include a proposed order. But I'm telling you, if you're hungry enough and you're desperate enough to see your child, just read through the process. At least here in Indiana, as I said, we have templates, and you can get into that court very easily.
In California, it's even easier. We're a form-based family court practice. So you don't even have to format your own document. You can find a form, and all you have to do is submit that form, and that's good enough to get you a court hearing. And I want to kind of rail back, because I think this is something that's very important. What is a proposed order?
Yeah, yeah, yeah. So a proposed order is simply stating to the court, uh, will you grant me a court hearing? That's all it
Hmm.
is. And it's an order that the court will simply say, hey, I'm going to grant you this court hearing, and the court hearing is going to be scheduled for April 15th at 2 p.m. in courtroom 2B. That's simply what it is. It's nothing deep or in deep depth or a lot of legalese in it. It's simply a form or an order which the court actually puts the actual court date to appear in court.
Yeah. And here in California, it may be a little different. In Indiana, it's typically we'll tell the judge in bullet point form essentially exactly what we're looking for.
Yeah,
Because of the things mentioned above, we are going to request that you do X, Y, and Z.
yeah,
And it succinctly says this is why we're here, this is what we're asking for, and kind of puts it in the judge's court. Right?
yeah.
That's probably a bad term to use. I'm using a basketball term. We got two Indiana attorneys on here, and Indiana and Purdue are playing basketball right now.
Oh, wow.
Yeah, I'm a Hoosier alum, so before we got on, that's what I was watching. So we're at about 56 minutes. We'll do one more question because this one's got a lot of information in it. So we'll go back to Bob again. Is 51%? So I think what he's asking is preponderance of the evidence enough to kick dad out of kids' lives for 10 years unless dad pays support and all mediated supervised visits despite everything being it. So there's a lot there. So I want to kind of tame it down a little bit. So 51%, I'm assuming we're talking preponderance of the evidence.
Mhm.
Unfortunately, I'll kind of take that piece of it. 49 of the 50 states, preponderance of the evidence is the burden of proof in family court. Arkansas, which passed their law last year, is the only state that has a clear and convincing evidence, which we would like to get passed in every state, but preponderance is enough. So when it comes to domestic violence, when they allege domestic violence, courts by preponderance of the evidence, much different than criminal court. If one feather falls on their side compared to yours, that's enough for them to make a finding that domestic violence occurred, that it's not in the best interest of the child for this to occur. So I'll kind of pass it to you to start this. So in terms of custody and visitation or custody and
Uh-huh.
parenting time and support in the state of Indiana, is there any link to the two or are they
Um,
completely separate issues?
these are two separate issues. Just because a father is not paying child support does not eliminate his parenting time. Now, that issue is going to essentially be addressed in the court, trust and believe. But a mother cannot say and have standing to have an argument to say, well, I'm withholding the child because he hasn't paid child support and he hasn't paid it in 10 years, Your Honor. Okay, is the judge going to be happy about hearing that? No, he's going to have arrears and he's not probably going to be able to file the child on his income tax every other year. But those are two separate issues. So using that as a argument, or if the mother is trying to use that as an argument in the state of Indiana, it's not going to work because you cannot withhold the child just because father is not paying child support or behind in child support.
Yeah, I think that's dead on for all 50 states is that custody, visitation, parenting time, whatever your state calls it, is a separate issue from child support.
Yeah,
So, like you just like we hear stories of dads can be forced to pay child support but have no parenting time. If you don't pay it, there could be potential criminal. I mean, you're talking about contempt,
yeah.
garnishments,
Mm-hmm.
bank levies, that type of stuff. But it technically can't have an impact, and a judge should not be able to use that as a reasoning for severing your parenting time. There would have to
Absolutely.
be some other reason that they have found that it's in the best interest of the child to sever your parenting time. So, once again, based on what you wrote, Bob, I would say that it's something you need to get in front of a judge. If you have parenting time or it's been suspended for something that's been found to be unsubstantiated, you need to get back in front of a judge.
Yeah,
And you have to understand she's probably going to file contempt or the state's going to come after you for failure to pay child support. But that's not a reason for them to keep the children from you.
Right.
All right, well, Deidra, we just passed the hour mark, and I promised you no more than an hour and 3 minutes. I want to thank you for your time.
You're
It's
welcome.
been a pleasure. I know we get to see each other and talk to each other a couple times a week.
Yeah.
But I want to thank you. I mean, like I said, the people believe you should be running for office.
Okay.
I'm excited to work with you. There's some things going down in the state of Indiana
Yeah.
that someone who has the beliefs and has the story of you is going to be able to impact and be able to help. So I
Absolutely.
want to thank you for that. And for all our viewers, I will be back next week with Dr. Robert Simon. We're going to talk about parental alienation. He's not an attorney, but he's an expert witness, so that should be interesting. Don't know if it's going to be as interesting as with you, Deidra, but we'll have to do this again. And
Absolutely.
want to leave to people. So if they're in the state of Indiana and they want to get a hold of you, so what's your website?
www.dnhlawllc.com. And my number
dnhlawllc.com. Okay.
and the
And
phone
then,
number
yes, give it to us.
is 317-982-7396.
Okay. And then also, I do know on social media, you are putting out some amazing content that's
Absolutely.
going to be coming out even more hot and heavy in the coming weeks and months. Where can they find you on social media?
You can just Google, not Google, but just put my name in the Facebook search as Deidra Haynes, and I'll pop up there.
Okay, awesome. Well, once again, Deidra, I want to thank you so much for your time tonight and all the information you provided. To all the viewers, I'll see you guys next week.
Thank you.